Welcome, everyone. Uh, in fact, it's a pleasure. I've always been lacking lacking an opportunity in Kollam, though we had attempted several times to conduct one of those sessions at least. And I was not that privileged that time. Now, in fact, I chose this subject for the reason that the Commercial Courts Act 2015 was introduced. And unfortunately, not many people knew about this in Kerala. Not only in Kerala, there are very few states which actually came to know about this. That's the worst situation. 2015, this was introduced as an ordinance. And when an ordinance is passed, most of the time we will know that there would not have been a proper discussion at the floor. And if such a thing goes in, the intricacies of a particular statute may also be not well noticed by the people. Drafting could also be a little weaker. Drafting would also be a little weaker in these situations. And expert drafting may not be seen in such statutes. We are aware of the DV Act. What transpired is also, we all know. But fortunately, this is not a substantive law. This is something more like a procedural law. And for advocates like us, the procedural law makes it much, much more important. Because I always used to say, if a person gets literally acquainted, a love in, when you fall in love with CPC, even the substantive law is given to you by the CPC, or the CPC would guide you as to where exactly you have to look at. If you take certain forms, that gives you what are the defenses. So you would get a lead to the substantive law that you have, all that. Now, here is a procedural law, which cannot be different from that of CPC. And I love process. I love procedure laws. So I thought, I would have a look at it even before this was introduced in the state. The law came in as I said, it came in as an ordinance in 2015. Passed a central act, therefore, it was passed by the president. In 2016, that is, it has to be converted into a statute. And after the floor started sitting, they discussed it and they made it an act without much of a change. It was just accepted, interestingly. And therefore, you will find the Commercial Courts Act 2015 is named as, if you see the name in it, you will find it is an Act 20, it is subsequent, it's an Act of 2016. Because the Act comes in 2016, while the exact statutes and the process got started in 2015. And when it comes in 2015, so many things would have been done under the statute. Therefore, under the 2016 statute, it becomes necessary to protect all the acts that were done under the ordinance. Otherwise, the particular period of 6 months would have literally been a waste if you don't protect those acts which are done by the judicial officers and the lawyers. So why was this brought in? This was brought in for tackling the ease of doing business concept, which was introduced by the ministry. The foreign courts, the foreign nationals, foreign business entities, they were finding it a little reluctant to come to India, saying that, we are not matured enough to handle commercial courts or, commercial disputes. So we were actually trying to be in tally with those areas, and those provisions, including those on the UNCITRAL, have been brought into this. Now, it is not something totally new to us, to India. Now, when you know, sitting in Kerala, we may not understand why sometimes certain laws are made. And when they are made, you will find it is totally alien, or it's in a totally different pattern. For example, when the DRT, the laws relating to the recovery of debts of 1993, they brought in the authorities and the courts under that and the formats. You would find this had nothing to do with the Kerala formats. But somebody who has been going into the other jurisdictions like Delhi, Chennai, Madras, Bombay, Calcutta, and the other areas where the presidency towns were there. And the way they were following the formats, you will easily identify that all those formats which have been introduced under a central statute would certainly tally with that has been applied or used in Delhi. Therefore, you will find a lot of things which are familiar to Delhi people or the Bombay people, Chennai or the Calcutta people, and which may be a little alien to us because it has been drafted at that level. They take their background, their information to do this, and you find everything that has been brought in would also be something that has been going on in Delhi. In 2016, and sorry, 15 when they made the law, and 2016 when they brought it as an act, you'll have to go to the background as to why they were thinking about it. Now, we did not have something called commercial section of a court, but Delhi, Bombay, Chennai, Calcutta, and Himachal Pradesh, the 5 states which had an high court with original civil jurisdiction like our municipal court or the sub-court. So there you have a constitutional extraordinary constitutional jurisdiction, you have the criminal jurisdiction, you have the civil appellate jurisdiction, and you also have a civil original jurisdiction where plain written statement, everything has been filed, and a trial also takes place in the High Court itself with a judge who is being called as a High Court judge, a single judge meant for a trial site. And all these had these commercial disputes over there, especially if the valuation was more than 1 crore. So any suit for that matter, if the valuation was more than 1 crore, it would have to go to the High Court and not in the other district levels. Of course, this applies only to the fort area. The fort area is where the Britishers originally concentrated. So if you take the presidency court in Chennai, the moment you come out of that particular designated area, then it would be something similar to us, like the sub-court or the municipal court. Now, if you see the 2015 ordinance, the valuation of a commercial dispute was tagged at 1 crore and above, which means this was meant to be for those high court jurisdiction which should not be lost. And practically this was being handled in these 5 states at that particular level. Now, that is something which you will find when you go through the provisions of this act. You will find more or less everything is basically to retain the High Court civil original jurisdiction. And they wanted something more, posh and more flowery kind of, which is the commercial disputes. Thereafter, they realized that this was not being popular in other places because seldom you had disputes which are above 1 crore, which has been brought in. And most of the states had not even taken initiative to establish the courts. So they made it mandatory, thinking that there could be commerce, there could be foreign investments, not only in these 5 states, but it could be in other places also. So they insisted that, look, this has to be brought into all the states. Accordingly, they literally had to make an amendment. Because with the original one, it became very difficult for us to have a jurisdiction similar to that of a commercial court, as we have planned it now. So in 2018, they brought in an amendment act to amend the original Commercial Courts Act of 2015. That amendment act brought in a lot of changes, which was intended also for the whole of the country. And there was a mandate that every state should start these commercial disputes, otherwise the commerce or the economy would be affected. The foreigners would not invest in India because they still face the threat. So for this reason, they incorporated a lot of change. With the changes made to the Commercial Courts Act 2015, they brought this 2018 provisions and they made it mandatory for all the states. Kerala had its notification constituting the commercial courts in 2020, despite all that, in 2020, February 24th. And therefore, you would find those people who have the statute, you will find that this has come into effect from a particular date. If you have the notification, which probably I can send to you, the state doesn't have much of a role. It can only notify the courts. It can only notify the minimum value for the purpose of jurisdiction to constitute a commercial dispute. So beyond that, the notification will not contain anything. So the Kerala notification says anything above 3 lakhs, which otherwise becomes a commercial dispute, shall be a commercial dispute and shall go to the commercial court. 2, it said a sub-judge, the principal sub-judge of every district shall be the commercial judge or the commercial court. And the appellate jurisdiction shall vest with the district judge, irrespective of the valuation. Only condition is that the minimum has to be, the minimum valuation should be 3 lakhs. Now we will look at the name of the statute. The statute is Commercial Courts Act. A court which is to handle commercial disputes. And the preamble itself says it's an act to amend the commercial courts, commercial division and commercial appellate division of the High Courts, Division of High Courts Act 2050. Now, interesting. Then it says for what purpose? It also says it is to deal with commercial disputes. Therefore, the term commercial dispute has to be understood. And if any word is not acceptable, not understandable to us, we all go into a dictionary. And every statute certainly has its own inbuilt dictionary, which is normally found in section 2, which is normally called as the definition. And that speaks the language of that particular statute and the special meaning attributable to each of the word that has been used. Pramod, I believe I'm audible. Is it clear?
Yes, sir. Yes. Yes, you're audible.
Okay. Audible, fine. Now, if I can ask you to take the, Pramod, if you can just load 2 of the main statute.
Yeah, of course.
Section 2. I've given you a,
yeah,
PDF file. So it'll be easy for everybody to see it also. No, you can just take it to the, the other one, the PDF one. PDF one. There's the PDF one which I've given.
Yeah.
Yeah. Because there's a large list of about 21 plus typical jurisdictions that they have mentioned. That's the reason I thought I'll just take the list. In the meantime, I'll certainly go through it. In fact, I'll just read it for your benefit. Section, it's worth noting the provision. Section 2C speaks about, it names commercial disputes and it gives a list of matters which are considered to be commercial disputes. What all would come within? And you will understand each of this would be coming under certain statutes. They are ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to the mercantile documents, including enforcement and interpretation of such documents. Very simple. All the banking transactions should certainly go into any business transactions which the merchants would handle, that would go into, including simple financiers. So that would also be the financiers and traders. Anything relating to mercantile documents, you can take LC or whatever, negotiable instruments, all that have been separately mentioned also. So anything customarily is something to do with a mercantile document or any business transaction as is understood or commercial transaction would certainly come within the scope of 2C1. Now there are lots of others which may overlap also in this. Export or import of merchandise or services. Now here is an exporter. Here is an, exporter from a different country exporting certain things to an importer in India and the importer doesn't receive it. So there is a lot of expenses to be paid at the port or the wharf, and the whole the materials that have been brought in will certainly have a charge in respect of these kind of liabilities, and therefore the exporter is also worried because the importer is not accepting it. Importer has been negotiating on so many things. Now, all these are issues. Now, there could be a lot of disputes, especially in port areas. And therefore, all this has a lot of relevance. And these are all going to be high-stake litigations. The third one, issues relating to Admiralty and Maritime. Now, this normally used to go. I'm certainly sure Mr. Unnikrishnan will be the best person to speak on this. Yes. Now, Section 2C, a little up.
Yes.
Pramod, Section
Yes.
2C. Yeah. And this is for the people, I mean, who have not, who don't have, probably have the statute, in fact. A little bit more.
Yes, yes.
Definition. Yeah. The next is issues relating to Admiralty and Maritime law. There could be ship issues, compensations, I mean, issues between a ship literally, I mean, damaging a boat, all those kinds of issues which might crop up. Now, they also would go into the commercial court, as they say. Then comes transactions relating to aircraft, aircraft engines, aircraft equipment, and helicopters, etc., etc., which certainly comes into the WhatsApp groups nowadays, whether there could be a liability and or anything relating to these kind of things. Construction and infrastructure contracts, including tenders. We have a plenty of these. There could be a lot of government contracts where you have infrastructure, I mean, contracts, bridges, rails, ports, any of those infrastructure ones. You know, there could be a lot of metro issues, and all these would come within this, including anything relating to tenders, etc., would certainly come into this. Now, the next one is agreements relating to immovable property used exclusively in trade or commerce. Now, interestingly, it is not every immovable issue, not a simple injunction suit. This has been clarified in one of the Supreme Court decisions. Probably I can certainly supply all this. It has gone into detail. The immovable property itself has to be seen as a commodity. So if you are dealing in immovable property, including you are a company where you get into constructions, leases, and all that kind of work, immovable property is a commodity, and the market is with respect to that, and that is exactly what is used in trade. So that is how it has been explained by the Supreme Court. It's a 2020 decision. 8, franchising. Now, there are lots of, every second day we hear, I'm a franchisee of such and such a company. I'm a franchisee of a big group of companies. And all those disputes which may arise between the franchisees and the principals, etc. Distribution and licensing, we are all familiar. Anybody who would be practicing in Kerala would certainly know that there could be a distribution of materials, etc. And there are licensing issues. I can use a license issued by somebody else for my benefit, all these kind of things. Then comes management and consultancy agreement. Today, every second person is a management consultant. You know that. There are lots of MBAs out there. All these, any of these issues, the disputes arising out of these agreements, this is what we have to see. Joint venture agreements, plenty of them, including in construction, you find it everywhere. Shareholders agreement. Shareholders agreements are agreements wherein I want to sell so much of my shares to Mr. Pramod, and we enter into an agreement. This is a purely commercial practice. Those who deal in company laws. So when there is an agreement entered, even prior to actual transfer, it is basically a reflection of an understanding with respect to the transfer. There is an agreement which is entered. There could be a lot of disputes which arise. At a later point, I don't want to sell it. I may back out from this. Lots of, and this is basically handled by the commercial group, in fact. Then, subscription, investment agreements pertaining to service industries, etc. Outsourcing. Now, Cochin, Trivandrum, all these areas find a lot of outsourcing companies. So anything relating to these kind of things. Mercantile agency and mercantile usage. Mercantile agency is, again, what we know. We have been learning mercantile law. It's not my specialization, at least. But there are lots of people who have done their mercantile law, and then the kind of disputes that can arise out of that particular kind of subject. Partnership agreements, I'm sure 90% or 99% of us must have handled this. Technology development agreements. Yes. something, this could be similar to that of the other one which comes under 17. I'll deal with it, in fact. Technology development agreement, somebody develops something and the disputes arising out of it. Then intellectual property rights, rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical, all these are related. We'll just call it an intellectual property. We know there are Designs Act, there are trademarks, Trademarks Act, copyright, lots of these. So patent, all these come under this. Anything coming within that now has been termed as a commercial dispute, capable of being a commercial dispute. Agreements for sale of goods or provision of services. This is with respect to movable. You can connect it to the other ones also, earlier trade and all that. Exploitation of oil and gas reserves and other natural resources, including electromagnetic spectrum, which probably we don't have much out here, but we still had one of those. I still remember sometime during 96 when we had a lot of shortage of electricity, Ernakulam had a power plant, a private power plant introduced by Reliance. And the disputes were, Reliance and KSEB, it's called a power purchase agreement. So there are lots of agreements. In fact, I have done one of those. I have been a lawyer for one of those matters, something called power purchase agreements. These go into large scale amounts. This could be between the governments, between the power agencies, etc. So these kind of things. Then, insurance, reinsurance, contracts of agency. Agency is something, trading agencies relating to any of the above. So in any of these, if you even act as an agency and if you enter into an agency agreement, so you need not even be the principal one, even all those things are now termed or brought under the commercial, commercial disputes. Any disputes arising out of this 21. Interestingly, there is something more that the government can. Such other commercial disputes as may be notified by the central government. So there could be a lot more of subjects, lot more of scopes. The scope could even increase at a later point of time, as to what could constitute a commercial dispute. Now, I think we would stop in the definitions. This is what is primarily required to understand what a commercial dispute is. Now, if I may take you to the next chapter, the chapter 2 relates to constitution of the courts. Now, there could be certain areas which may not be familiar, which may not be relevant to us. They have divided the whole country into 2 categories. One is those 5 states which has a presidency court or a court with original civil jurisdiction, originally itself. Now, there are 5 of them which they have identified. Now, as on date, the certain provisions would apply only for those particular situations. They are: 1, as usual, Delhi would come in, but originally the 3 presidency courts, which being Calcutta, Madras, Bombay, Delhi, and Himachal Pradesh. They have a judge who sits in the civil original jurisdiction, literally meaning that they would act as if it's a municipal court or a sub-court, and they practice the same CPC for the purpose of dispute resolution. Now they say under 3, I would like to summarize and go so that when you read the provisions, you get the knack of it. You get the whole understanding, the contents of it a little faster. Now, in states like Kerala, if I next refer Kerala, it means all those other states. And if I say Delhi, then you would mean it as the 5 states. Now, in those areas, under the Act, the High Court is supposed to start. The High Court is supposed to start a commercial division, as they call it. Like the constitutional, the civil, earlier we had the company division. Similarly, now they have something called the commercial division. And under the commercial division, there would be judges who are acquainted with these kinds of, their expertise is in these kind of commercial subjects. Or they would be trained to handle these kind of subjects. And there would be an appellate division, which is supposed to handle all the appeals from the commercial division court or the division bench. Now, so that is with respect to the 5. Now, coming back to R.
Excuse me, sir. Excuse
Yeah.
me, sir.
Please.
Without interruption, within 1 minute, this session will close. All are requested to re-enter with the same ID and password when this session stops. You can continue, sir.
Yeah, fine. Yeah, fine. Now, as far as Kerala and the similar sister states are concerned, it is you're supposed to have a court subordinate to that of a district court, which would be the original commercial court. Now, the word used is commercial courts, and there will be yet another one on the appellate side. That is supposed to be a district court. Now, very interestingly, this is a very badly misunderstood statute. Now, if you check how these courts have been accepted, Pramod, I believe there is something being coming on this, in fact, writings. Yeah, if you see, even in Maharashtra, what happens is, or in some of the states, what happens is, they have originally appointed a district court mistakenly, and now they have come back to the subcourt itself, because they thought a state could also have a district judge as the commercial court.
Yeah, so when it comes to Kerala, it says that it has to be a judge subordinate to that of a district judge, and therefore it has to be a subcourt. Now, that is why under the notification, what has been done is that Kerala has made the principal subordinate judges as the commercial courts. Now, there is one definition that we may have to look at. What would be a commercial dispute? A commercial dispute can be something of a particular specified value, and the statute says not below 3 lakhs. And any state government can refix the value, which means Kerala can certainly go with a value which would start as 10 lakhs. The minimum valuation for a dispute to become or to be tried by a commercial court has to be declared as 10 lakhs or 15 lakhs, and according to the whims of the state. Now, what Kerala has done is Kerala has not made any dilution. It has just gone into the same figure and it has gone with 3 lakhs. So, any matter which comes within 2C with a minimum valuation of the dispute as 3 lakhs would become a commercial dispute. Therefore, lots of matters from the municipal court would also go into the commercial court, which is the principal subcourt. And unlike the other courts, it is indefinite. I mean, unlimited is the valuation when it comes to a principal subject. The risk that we are going to face is that almost 60% of the cases are going to be transferred. If this is the kind of list that we have, 60% of the cases would certainly be transferred to the principal subject. Now, is it possible for a subject to handle this? Let us see how they have formulated the provisions so that they can make it go in the 4th gear. Now, this would be the summary of section 3. Now, we will assume that it has to be the principal subject. Henceforth, if you have a commercial dispute where you will have to file the case. Secondly, the appeal from that, wherever permitted, not too many appeals are permitted from this. Our right to appeal or our right to revisions are all restricted. There are limited provisions for challenge. So in such situation, if at all it is permitted, and that is what is available under Order 43, and that would certainly go into the district and the regular appeals that we have. Now let us get, this would be sufficient for section 3 for us to understand. Then section 3A speaks about the commercial appellate courts. Then we have 4 is not relevant to us because it is only if you want to go to any of those Delhi courts, in the sense the 5 courts that you would like to go, as far as 4 and 5 are concerned. Then, now let us take bar against. If I can draw your attention to section 8, Pramod.
Okay, sir.
Can you just take them to the statute?
Yeah.
That is the act. PDF. In the meantime, I'll just read the section.
Section 8, sir. Yeah.
Section 8. Now it's in 2. Yes. That's right. Bar against revision application or petition against an interlocutory order. Now, notwithstanding, the major problem that our courts face today is every interim order is being challenged in the High Court. Either you would go under 227 or you used to go under CRP. Now, probably they've tackled it to Section 8. Notwithstanding anything contained in any other law, for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction. So earlier we used to say in a revision that there is an exercise of jurisdiction which is not vested, or there's an excessive exercise of jurisdiction, or there is non-exercise of jurisdiction or an improper exercise of jurisdiction. Now basically the question used to be that of a jurisdiction. Now they would say, no, it is not permitted. You cannot. You will have to suffer whatever the decision is. Now, and any such challenge subject to the provision of Section 13 shall be raised only in an appeal against the decree of the commercial court. So after, this is when does this happen? This happens when the commercial court assumes jurisdiction. It says once you raise a jurisdictional doubt, then a dispute, then if the commercial court finds that there is no jurisdiction, you certainly have a right of appeal because you have to go to the other one. If it says that it has got jurisdiction, you will have to trial with the whole thing. You will have to finish the whole the trial, then get a decision. It is along with the appeal that the jurisdictional issue would be decided if the commercial court proceeds with it. Then it comes to 9. Transfer of suit if counterclaim in a commercial dispute is of a specific value. Now let us see. Notwithstanding anything contained in the Code of Civil Procedure, again, here is an exclusion clause. Notwithstanding anything contained in the Code of Civil Procedure 9, in the event that a counterclaim filed in a suit before a civil court relating to a commercial dispute is of a specified value. So what is specified value? Specified value is determined as 3 lakhs by default, and if not, if you decide the specified value for the minimum jurisdiction so when we say commercial dispute, a commercial dispute triable by a commercial court. Now you may ask me a question, can there be a commercial dispute if 3 lakhs is, if the value is 3 lakhs and below? The nature of the dispute possibly could be 3 lakhs, as that of a commercial dispute, but it may not be triable by a commercial court. That is the only distinction. Anything which would, though the nature is of a commercial dispute. Now 1 lakh I purchased, I had a trading account or I had a trading transaction, but the dispute is only with respect to 1 lakh. That would not be a commercial dispute for the purpose of the Commercial Courts Act to be tried in a commercial court. So that is why the word specified value is being mentioned. Now, the suit would be transferred by the civil court to a commercial division or commercial court, as the case may be, having territorial jurisdiction of the suit. So there is yet a risk. Even a civil matter would also be decided by the principal subject if a portion of which is that of a commercial dispute. And the easiest way to do is, if you have a commercial relationship with him, and if you raise a dispute on that, probably you can drag this matter also in a counterclaim. You can drag this also to the civil court. The commercial court. Then it says, if this is the situation, let us see. What happens if something is being agreed to be resolved by arbitration? Section 10 deals with it. Jurisdiction in respect of arbitration matters. Now, the trial portion is covered by the arbitration agreement. Therefore, the arbitrator will not, I'm just summarizing it, the trial portion or the first decision by the arbitrator is not excluded. He still continues to get the authority he will certainly complete the arbitration modality because that has been decided by the parties jointly under a special statute. Therefore, that is protected. Then what happens? Therefore, anything relating to an arbitration, which is not to be decided by the arbitrator, but to be decided by a civil court otherwise, all that is to be transferred to the special court or the commercial court if such arbitration relates to a commercial dispute or anything which comes within 2C. That is what the summary of Section 10 is. Now, if you go through Section 10, we will see where the subject matter of an arbitration is a commercial dispute of a specified value, and if such arbitration is an international commercial arbitration, all applications or appeals arising out of such arbitration under the provisions of Arbitration Conciliation Act 96 that have been filed in the High Court shall be heard and disposed of by the commercial division where such commercial division has been constituted in such High Court. But this does not relate to the appointment of, not the arbitration request which is to be handled by a Chief Justice or the designated judge. This only relates to other applications. Then, if such arbitration is other than an international commercial arbitration or a domestic arbitration, all applications or appeals arising out of such arbitration under the provisions of the Arbitration Conciliation Act 1996 would certainly be disposed of by the commercial court. Now, I'll just give you the sections under which probably you may have these kind of matters originally with the district court. Let us see. One is when you have an appeal filed under Section 17 or Section 9, when you go to a civil court or a district court for the purpose of interim order. So Section 9 applications henceforth will be handled by a commercial court if the matter pertains to a commercial dispute. Next one, let us take Section 17(2), which provides for certain appeals. In the, not in this, I'm sorry, Pramod, that is under the Arbitration Conciliation Act.
Okay.
Yeah, I'm sorry, because you have Section 9 petitions before the arbitration court, the district court. It's called OP arbitrations kind of, or CMA arbitration, CMP. Now, then you have under 17(2) certain applications before the district court. Then you have under 34 and 37. Therefore, these are the applications which normally go before the district court or the civil court. Now, all that would be now determined by the commercial courts. Therefore, effective 24(2), all these matters which are pending before the district court would also have to be transferred. So why I suggest this is because tomorrow if you have a matter in the district court when it reopens, it is better not to argue that because it is hit by lack of jurisdiction. It should have been treated as transfer, which means post-COVID, none of the commercial disputes are going to be decided for at least 2 to 3 months because all these transfers and other issues would be the priority at that point of time. Now, so that is what is covered under Section 10. Now, if you take Section 11, very important to understand, construe and understand. Bar of jurisdiction of commercial courts and commercial divisions. Now, until now, we said that a civil court would have, jurisdictional bar to handle this. Now, which are the matters which otherwise would come under 2C, which means the nature of dispute is that of a commercial dispute. Still, here is the bar for the commercial court or the commercial division of the 5 courts, the Delhi courts, to handle this. They are, that is what has been mentioned. We just go through the text itself so that it remains in our mind. Notwithstanding anything contained in this act, so all the provisions under this act is suspended when it comes to 11. A commercial court or a commercial division shall not entertain or decide any dispute, any suit, application or proceedings relating to any commercial dispute in respect of which jurisdiction of the civil court is either expressly or impliedly barred under any other law for the time being in force. Now, what does this mean? It means under 2C of this particular act itself, there's a list of things which would have otherwise been treated as commercial dispute. And they all are above the specified value, which means, let's assume there is a issue, there is a commercial dispute which is worth 10 lakhs or 10 or 12 lakhs. Now, this pertains to intellectual property. Here is a bar which applies. See, when 2C was brought in, they did not think about the Kerala condition. They were always thinking as if he is a Delhiite. And what would happen in Delhi, that is all that went into, even after the amendment, that is how it appears. Now, in Kerala, under the special statutes like Patent Act, Designs Act, all the intellectual property, the Copyright Act and the Trademarks Act, there is a specific clause under the provisions of that particular, statute, that all these matters shall be decided by none below the status of a district judge, which means no civil court can actually entertain this. No court other than that of a district judge, which means impliedly there is a bar. Impliedly there is a bar on the commercial court, to the extent that unless the commercial court is that of a district judge level, you cannot hear it. Now, this is possible only in the 5 states as it stands today. Very interestingly, Maharashtra, we'll assume it this way. In any court where there is a presidency court, where there is a commercial division which is handled by a single judge, and there's a commercial appellate division which is handled by a division judge, they were given a liberty. Apparently because of district, so the High Court thinks that why should I be handling anything below 1 crore? So they were given the liberty of appointing even someone at the level of district judge for certain jurisdictional values, which means anything below 1 crore otherwise would have to be dealt by a by a High Court judge. Now what is given to them is that anything below 1 crore, which is the tag for a High Court judge to look at. Now anything below that is now given to a district judge and the state can appoint. So practically everywhere, all these 5 states, union territories in the 4 states, they have appointed district judges also as the commercial court for all matters which is below this. And the appeals would go into, from this court, the district court also, to the appellate division of that is the division bench of the High Court, not in Kerala states. Not in Kerala state means not in those states which are at par with Kerala. Now, there, they may not have this kind of an issue. Even with respect to arbitration, if a district judge was supposed to handle the section 17 to section 9, section 34, section 37, petitions or applications or appeals and all that, then they may not have an issue. But very interestingly, in all these 5 states, 4 states in the Union Territory of Delhi, that is also handled by the single judge of a High Court. That is what our district judges handle under section 34 is handled by a High Court judge. So there also probably all these things would certainly go into the commercial division. As far as the Kerala lawyers are concerned, even those petitions would also come into this, whereas all those which are barred, like under the Intellectual Properties Act or other matters, where a district judge or somebody above has been designated, or where a civil court otherwise is barred, generally barred, all that would continue with the special jurisdiction under those statutes. This is just for you to look at. Now, I do not know how the judges are going to interpret this. We feel that this is the only way that somebody can interpret this when it comes to bar on the commercial court itself. Now, we would have, let's take 12. How do you determine the value? The value is determined exactly the way we have been valuing a suit for all practical purposes. So it is exactly that way. And that's what it says. Specified value is what is being referred to under section 12. If you have a dispute, the value of which is, assume it is above 3 lakhs, then it would be shown. And normally look at this, where there is a monetary component attached to any claim, it would be the monetary component which would be looked into for the purpose of the specific value. Now, there's only one. We'll just take D, 12D. Where the relief sought in a suit, appeal or application relates to any other intangible right, the market value of the said rights as estimated by the plaintiff shall be taken into account for determining the specified value. There's a little leverage that is given to the lawyers. So if you are in the border area and if you wouldn't mind, valuing it in such a way that you would like to avoid it, probably you can bring it under 12D. That's only exception. Rest everywhere you will have a monetary value that is being shown. Now look at the counterclaim that has been added after the amendment, where the counterclaim is raised in any suit, appeal or application, and the value of the subject matter of the commercial dispute in such counterclaim as on the date of counterclaim shall be taken into account. So there is a suit which is filed before the municipal and which certainly relates to 2C, but since it does not touch 3 lakhs, it continues to be in the municipal court itself. Now, somebody raises a counterclaim which goes above 3, immediately the whole thing would be one way or the other. If any of the subject matters, either be it in the counterclaim or it be in the main claim itself, and if that satisfies section 2C requirements, it would certain, and it is not hit by, again, it is not hit by section 11 bar, then it would certainly go to the commercial court stage, as the commercial court. Something that is interesting that has been brought in is, and what made most of our mediators prompt to look into this is, even before the act came in, much earlier itself, we have been looking at this, is chapter 3A, which was introduced, which is section 12A. Section 12A mandates, it's called PIMS, Pre-Institutional Mediation Settlement. You have to attempt for one of such. And therefore, if somebody has to file a commercial suit, a commercial court suit, then he will have to apply to the District Legal Services Authority, which is the competent authority for entertaining this. You will have to make an application over the, just narrating the summary of the claim and asking for arranging a pre-institutional, that is prior to institution of a suit, such a mediation, and the DELSA would appoint one of the designated or empaneled commercial mediators for the purpose. And there's a time that has been given, a maximum time from your application is 5 months, within which if it is getting settled, excellent, then you will have the court is not even going to look at it. It is more like a conciliation at the instance of a mediator, a trained mediator, and such would be the accepted decree for all practical purposes. It doesn't say decree, it says it is more in the form of an award under Arbitration Conciliation Act under section 10. So this is how it says. Therefore, henceforth, you cannot just file a suit before the Commercial Courts Act, even if it qualifies to be a commercial dispute, unless you invoke section 12A and complete that procedure also. That's called the PIM, Pre-Institutional Mediation. Now, it is so easy for people to come out of it. So many ways. You apply for it, and then you come out of it saying that no matter did not settle. You can even tell your client that, okay, I'm supposed to, it didn't work out very well. Unfortunately, all this is also noted when it comes to costs. Now, the cooperation of the party and the counsel with that of a commercial court is considered to be the good practices and the best practices which are supposed to be followed in the country. Now, we'll see the consequences when it comes to the rest of the provisions. Now, so please understand about this procedure. It may not be much of importance to you. Mediators have been studying this very, very detailed. But as far as the lawyer is concerned, when he is going to advise, this is what is to be required. The sad part of it, or the painful part of it for the party, would be that, like the arbitrations, there is a mandatory fee fixed, unlike the today's, what you see today as mediation, where it is totally free, everything is being done free. In this, there's a minimum cost of 15. There's a schedule of cost that has been given, and that cost is, the mediation fee would come to 15, 20. There's a table of costs which are provided for this for guidance. Whether a party would be willing, would be happy to go for a mediation spending 15,000 rupees is yet another thing to be, to be looked into. In fact, not necessarily people will feel encouraged, but there is yet another aspect to it. If you do not do this, the cost implication that is, that is going to be faced by a party would also be very, very severe. And we'll be looking at it when we deal with the amendments in 35A, section 35, 35A, 35B, etc. We'll come to it. With respect to 12A, how is the mediation to be conducted? A special set of rules have been formed, and it says that the central government is expected to make rules under this, and the central government has made. That actually came in 2018. So we have the PIMS rules, the PIM rules, that is Pre-Institutional Mediation Rules 2018, which is a little elaborate, and it is according to that procedure that the mediation would also go. I may not venture much into it because you may misunderstand me being a mediator or a mediator trainer that the whole scope of this particular session is towards PIM. I leave at that. Then we'll go into the next one, which probably would be interested as far as a lawyer is concerned. One exception to 12A is exactly like Section 18 notice, which is a mandatory condition for a suit to lie. Now, there is also an exemption where urgent orders are necessary, or certain kinds of suits where urgent orders are inevitable. A party is entitled to waive or circumvent Section 12A and file a commercial suit directly with the court. He may say 15,000 or the other cost, and for the purpose of this, for the interim order. But the Supreme Court has observed that if a party files an interlocutory application to come out of Section 12A, and if the judge finds that such an application was not really urgent, or if it was, it appears to be a little frivolous or vexatious, and it is only to circumvent a particular process, the court shall deal with it in such appropriate manner. Appropriate manners, heavy cost. And this is also included in the new amended 35A for the purpose of compensatory costs, etc., and other costs. Now we get into 13. 13 speaks about appeals. There are hardly 2 or 3 more sections to be dealt with. Chapter 4, appeals. 13 speaks about the appeals. Now I mentioned that Order 43 appeals are available. That is as against appealable orders. Now the regular appeals from the subcourt would lie with the district court. Nothing further is mentioned. So that is how it is, and that would be at the end of the whole process. Now we may go through Section 13. Any person aggrieved by this judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. 1. Any person aggrieved by a judgment or order of a commercial court at the level of a district judge, which does not apply to us at all. The rest certainly would relate to the Delhi courts. Now the proviso also goes into that, provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under 43 of the Code of Civil Procedure, as amended by this Act and Section 37 of the Arbitration Conciliation Act. Therefore, what originally would lie under Section 37 from the district judge to the High Court. The same appeal would lie from a subcourt, that is subcourt in the sense a commercial court, to a district court. Therefore, henceforth, the 34 would lie to the subcourt, and appeal from such an order would certainly lie with the district court. And anything which would come under 43 would also lie with the district court and not with the High Court. Notwithstanding anything contained in any other law for the time being in force, of letter patent, etc., shall lie from any order of a decree of a commercial division. Again, that deals with commercial division or commercial court, otherwise than in accordance with the provisions of this. So, those would also be controlled by this. Now, in short, the Commercial Courts Act controls practically all kinds of litigations when it comes to commercial matters, except those which are barred by 11. 14, it says expeditious disposal of appeals. It has given time for the appeal to be disposed of. The Commercial Appellate Court and the Commercial Appellate Division shall endeavor to dispose of appeals filed before it within a period of 6 months from the date of filing of such appeal. Very interestingly, you will not find a similar provision which deals with the trial side. So within how much time a commercial court should dispose of a matter is not very clear. There is no, similar kind of period is not being given. Of course, there is a period given over there for every small stage. And after a particular stage, it's a special procedure which has been, brought in, which is called case management under Order 15A, which has been introduced now. After that, yes, there is a particular period of 6 months which has been given. But still, as such, once you file a commercial suit, how long it would take or within what time a court should dispose of is not very clear under the statute. 15 enables the courts to transfer. It says all pending matters which would be governed by or which would come within the definition of Section 2C commercial dispute will have to be now transferred to the commercial court. So which means the first subject, the principal subject is going to be flooded with all the matters. Then, now let us take 16. Very, the deadly provision that I would say. For a person generally for people who have been following civil procedure very religiously, fully, involving the CPC provisions, I do not think there has been much to worry about. But unfortunately, what we have seen is, in our state, I understand that there are jurisdictions like Kasaragod and Neyatingara where people literally exploit every rule, every clause of CPC when it comes to trials. And they exploit all the techniques and tools that are given to a lawyer for making things faster, making things a little slower. So for them, there is nothing that they would find it difficult or strange. But people in most of the jurisdictions, most of the districts, have not been exploiting the provisions of the CPC. These amendments actually should be understood after understanding the pre-existing CPC, those particular orders or the provisions. And if we compare the amendments with that, after knowing that, it would be much, much easier for all of us. 16, anyway, we would be dealing with it. But I'll still take all of us through 16 for the purpose of just acquainting it. The provisions of the Code of Civil Procedure shall, in their application to any suit in respect of commercial dispute of a specific value, that is about 3 lakhs now, stand amended in the manner as specified in the schedule. So, to this statute, there is a schedule. That schedule says which all provisions of the CPC have been amended for the purposes of a dispute resolution before a commercial court. Therefore, the CPC as it stands is very important for all the courts other than the first court, while a new CPC or certain CPC provisions as amended will have to be understood for the purpose of conducting all the issues, all the trials before the commercial court. Now the latest books have already started printing with the appended, the amended provisions appended to the orders. At the end of it, they've already started appending it. We'll come back to it now. The commercial division and commercial court shall follow the provisions of the Code of Civil Procedure 1908 as amended by this Act in the trial of a suit in respect of commercial dispute of a specified value. Therefore, anytime we say commercial dispute, we'll understand it as commercial dispute of specified value. Where any provision of any rule of the jurisdictional high court or any amendment to the Code of Civil Procedure by the state government is in conflict with the provisions of the Code of Civil Procedure as amended by this Act, the provisions of the code as amended would prevail. Therefore, certainly we will have to look into the amendments brought in by this Act, because if you do not comply with these amended provisions, as I see, your claim could be rejected. Your written statement could be rejected. So for a mistake of not understanding this or not following this, the client should not be permitted to suffer. Now, though we have had such provisions where you are bound to do certain things, pay the balance court fee in a particular time, if not, you will not be permitted, or file the written statement within so many days, and if it is not within 90 days, there is a bar on, actually filing it again, or with a delay. We have diluted it, including our own, apex court has diluted, saying that it shall not. Probably it is because of that in the text, they have actually brought in a clause that if you do not file it within the statutory period of 120 days, if permitted by the court, otherwise 30 days. then no written statement shall be accepted thereafter. Now, very interestingly, the matter was taken up with the Supreme Court. Supreme Court has confirmed that particular provision, saying that beyond 120 days in a commercial dispute, there is no question of receiving a written statement. So it becomes very important as to know which are these kind of checks that we have, or which probably can lock us down. We get into Chapter 7 is practically, that is not much meant for the lawyers here. It is more on the administration, etc. Collection and disclosure of data of commercial courts, not for us to do. When the suit is disposed of, it is for the court or the DLSA to do that. Basically, the High Court will have to maintain, they have to report it. Power of High Court to issue directions. Now, High Court can periodically issue directions for the management of the commercial courts as long as they are not inconsistent with the provisions of this Act or the CPC as amended by this. So again, there is a restraint on the High Court. As otherwise, Section 122 of the CPC permits the High Court to modulate any rules, which we call as the civil rules of practice, all which are made under 122. And the High Court can modulate it. Or they could even amend the first schedule, which is nothing but the orders. So High Court had a lot of control on its own courts. But when it comes to commercial court, there is a common general practice throughout the country, and that has to be complied with. So that is the importance that we find in 18 and 16 and all that. Very interestingly, the Act realizes that it is not a small thing to do. This is a very specialized job, and it requires excellent domain knowledge. Therefore, Section 20 is incorporated. Section 20 says training and continuous education of the judges. So the judges who have been judging all kinds of matters all these days without an option, now they are asked to get even trained in each of this. There are so many things. So as I understand, and as has been found from the academies in other states, we are yet to start on this. Even the syllabus is yet to be prepared for the judges training in this. Now, in the other states, including the 5 states, the 4 states, and the Union Territory of Delhi, what they have been taught are all those relevant matters coming under 2C and the various statutes which actually regulate the various subjects or which control or which has a domain on these particular, Section 2C subject matters, various trading and all those kinds of subjects. So it is to that extent. My yet another worry would be that the one who is going to sit today is not necessarily going to be the commercial court in the next day. So it becomes a tedious work basically for the Judicial Academy to train every person, and somebody who comes in new as a commercial court judge, unless he is trained, if he is not in a position to handle, again, we lawyers are going to be in trouble, because for some time, at least in the initial days, the judge, until he gets trained under this, it is going to be a mess in the court. Again.
Excuse me, sir. Within
Please.
1 minute, this session will be closing. All are requested to re-enter with the same ID and password. So you can continue.
Yeah, fine. Now, 20. We would always, normally, it's a statutory, legislative process that you have an overriding effect which has been clarified. Section 21 says, save as otherwise provided, the provisions of this Act shall have effect, notwithstanding anything inconsistent therewith, contained in any other law for the time being in force. It has to be, yes, being in force, or in any instrument having effect by virtue of any law for the time being in force other than this. Again, so this becomes a supreme constitution as far as the commercial court is concerned. Now, central government alone gets the right to make the rules. Now, when we go through, now this is the scheme that they have brought in. How a court should be, a general idea that is given. Now, in CPC, we always say there are different parts. So at times when I ask people, how many parts does this CPC have? An instant answer is, yes, we have 2 parts. One they would say, yes, the sections and then the orders. And unfortunately, people have not gone beyond that. Now, I always used to see the last part. There is yet another part to the CPC, which is seldom used, seldom learned in the college, seldom learned from the seniors, seldom learned from the, or at least pointed out by the judges, and therefore it is practically unutilized. And why I say this is because there's something called the appendix involved in it. Appendix, I'm sure some of us, and especially in certain areas, I've seen, appendix being religiously utilized. It is this. Now, it is easily understood this way. CPC has made it very, very easily understandable. S, which talks about section, I would call it as sections gives you the scheme. And O for orders, which is for the orderly pattern that we have. So if you see order 1 to order 20, it is so well meticulously orderly placed that one after the other gives you a little direction to your the process. And it also mentions all the guidance that you get from the CPC. And in the initial stage itself, it says, please follow the illustrations that I have given, the formats that I have given in the appendix or various appendixes. And just a take home, I'll just give you a simple hint of, as to how we look at the appendix, which is also referred in this. Now we are going to start into the section 16 amendments. That's the reason I thought I'll just explain it first. There are 5 appendices. And just not 5, there are several. It has gone up to G, H after the amendments. Now let us take at least 5 when it comes to commercial codes. A, B, C, D are mandatory when it comes to trial. These are the techniques which a civil judge has or a lawyer who is an officer of the court has to make the whole trial process excellent. It makes it faster, it makes it more effective, and I would even call it as, it's called the silent trial or non-verbal trial, which means you don't even have to open your mouth from filing a plaint to the passing of a decree. And there are techniques which are given under the appendix. Now I may just summarize it this place, which probably you can look at when you go home. If you take CPC, let me take the first 4 itself. A for advocates, B for bench, C for common, D for decree. And if you want, after decree, if the party doesn't listen to you, you can even go for E, the execution. Now A gives you all the formats, plaintiff, the plaints as well as written statements. That's why we call it as the guide for the advocates. B gives you for the bench, which means it gives you all the kinds of summonses which is exclusively to be issued by the judge. And C, which is a common appendix, which gives you the formats of how you apply, how the court should be ordering, and how the other party should be complying. And D even gives some guidances to the judges as to how a judgment and a decree has to be written. And E, for all kinds of execution applications, all kinds of objections, all whatever you can infer from Order 21, you will certainly find in Appendix E. What more kind of a guidance that we need, from such a statute? This is what I always, this is why I have enjoyed CPC to such an extent. Now, Section 16 talks about the amendments. Can we look into the amendments now?
Sir.
We will have the next one from you.
Okay.
Let this be the, yeah. Can we have the next one?
Yes, sir.
Yeah. Not 16. There's a Word document which I have.
Oh, okay.
Right?
Yes.
Yeah. Now, if you refer section 16, it speaks about a schedule. It speaks about a schedule. Yeah. The schedule is relating to amendments of the CPC as or brought out under this particular statute. Let's see what it is. Section 26 is the first section which has been amended. What is the amendment? The difficulty is unless we carry a CPC along with us, maybe it will be a little difficult for us to compare as to what the amendment is. So if you have that, please keep section 26 of the CPC also with you. Now, very interesting. Most of you must have seen that we write the plaint, when we write the, prepare the plaint, 99% of the people have been writing it as plaint presented under Order 7, Rule 1. Suit for money, etc. etc. This is the normal format that we have. And certainly in the beginning, we write in the court of so-and-so, so-and-so. Or before the honorable support. Even to these small corrections, the CPC has been helping us. It is not Order 4, Rule 7. It is not Order 7, Rule 1. It is basically Order 4, Rule 1, which enables or which talks about presentation of the plaint. So it is always advisable to say plaint presented under Order 4, Rule 1. And Order 4, Rule 1 says that it would be registered, Order 4 says it is registered, the plaint would be received provided it complies the requirements of Order 6 and Order 7. And if it complies, Rule 2 specifically says that it would be entered and given a number in the register of suits. 26 is a section under the schemes for Order 4. And it says every suit shall be instituted by the presentation of a plaint or in such manner as may be prescribed. Now, as may be prescribed is an excellent word or a clause that has been used in CPC. Wherever you find as may be prescribed, you will find the prescription in the latter part or more so under the orders. Now, in every plaint, facts shall be proved by an affidavit. This is the second section that has been incorporated in 2002. And we all have been following it. Now, the commercial code says that a proviso has to be added into it. It says, provided that such an affidavit shall be in the form and manner as prescribed under Order 6, Rule 15A. Now, Order 15 rules, Order 6, Rule 15A speaks about verification and affidavit. Therefore, Commercial Codes Act, when you purchase this, you will find that there is a format of an affidavit which is provided. And there's a larger clause that has been given. 1, 2, 3, 4, 5. There's so much that has been given under that particular format. And that format is given, Pramod.
Yes.
I think you will find it in Appendix 1. Towards the end.
Okay.
Control end addition. Sorry, matte statute letter. Sorry, matte text. Okay. Now I will read it.
New share.
The text itself is, the text itself is more British, more as you see in Chennai or Calcutta or any of those presidency courts. I am the party in the above suit. I so and so solemnly affirm and state, etc., etc. Then I am the party in the above suit, competent to swear this affidavit. I am sufficiently conversant, etc., etc. I say that the statements made in paragraphs are true to my knowledge, and statements made in such and such paragraphs are based on information received, which I believe to be correct, and statements made in such and such are on legal advice. Therefore,
Appendix 1, sir.
Appendix 1. It's called Statement of Truth. So our old verification by way of an affidavit now has to take this also. It says it has to be an affidavit, and they call it a statement of truth. And that affidavit by the party says in the plaint, such and such paras are, even in the original, CPC, you have this in the form, the prescribed appendix. But unfortunately, we don't follow this. And I don't know if the person who has corrected this has also not seen the CPC when they incorporated this. Because the text originally itself has all these kind of things. But what I'm going to say this here is, when you write this particular paragraph in the affidavit, if I am the defendant, I am so certain that such and such are to be proved by him. And contents of certain paragraphs are supposed to be proved by somebody else because it is on information. Or such and such paragraphs are inferred by him on the basis of documents. Now, information is one thing, knowledge is another. What he has, direct knowledge. So we have a very clear idea that the plaintiff or the person who has sworn this affidavit knows so many things and he is going to be examined for this, and somebody else is going to be brought in. Even the small things in this gives you a lot of hint. So that is the para 3. I say that there is no false statement. The next is very crucial. I say that there is no false statement or concealment of any material fact, document. Earlier, you have to say so many things. But here is a statement now which says, I say that there is no false statement at all. Secondly, there is no concealment of any material fact. You needed to bring out what was material, not what would be material and beneficial to the other side. Even that is material when it comes to a trial. So what is material? I have not concealed any material fact, document or record, and I have included information that is, according to me, relevant for the present suit. Very interesting. That means you will bring in every document which is relevant to this. If it is within your control, or if it is not within your control, you are supposed to mention this. And the test is not whether you want it or not. The test is that the judge wants it. So the whole process is getting a little more refined to such an extent that it is not 1:1. It is the judge who wants to give a judgment, and you will have to assist him if you want your disputes to be concluded. Irrespective of what you're producing is good for the other person or bad for me, I am supposed to produce this. Now look at this sentence in 4. This is the implication of this, that I have not concealed any document, any fact, or any material which otherwise is relevant for the purpose of complete decision of the case. Now, I say that all the documents in my power, possession, control, or custody, this is the 5th para, custody pertaining to the facts and circumstances for the proceedings initiated by me have been disclosed and copies thereof annexed with the plaint, and that I do not have any other documents in my power, possession, control, or custody. So there is yet another affirmation by oath. I say that the above mentioned pleading comprises of a total of so much, so the party knows how many pages, each of which has been duly signed by me. I state that the annexures hereto are true copies of documents, etc. Now, if you want to comply with this particular affidavit, then you have to understand the amendments threadbare. And to understand the amendments, most of them are inserted or by omissions, which means the old one will also have to be very, very thorough. Now let us go back. There are 2 ways. There are 2 formats which are given. Format 1 speaks about the party. The other one speaks about a person who is representing an entity. Therefore, that is the only difference that you will find in the 2 formats. Now we go back to section 26. 26 speaks about this kind of an affidavit which is being made mandatory. Now, there are lots of other sections. All those applicable, the scheme of CPC is applicable except to the extent that this act modifies. Now the next one is, we will go to 35. Pramod, can you just help me?
Yes, sir.
Section 35, Pramod.
Oh. So it's in the screen, huh?
Screen 35. It's the same Dinatha.
Word format, sir.
അല്ലല്ല ഇത് തന്നെ സെയിം. ഇപ്പൊ കാണിക്കുന്നതിനെ മുകളിലേക്കാക്കിയാൽ മതി. ആ വേർഡ് തന്നെ ഇത് മുകളിലേക്കാക്കിയാലും അതിനകത്തും ഉണ്ട്. മറ്റേത് ഫുള്ള് ഞാൻ തന്നിട്ടുണ്ട് കേട്ടോ PDF. Complete amendments. Yeah, 35. That is 35A. A little down. I know. I mean the amendments are probably double that of the text itself. But I wanted to let you all know that please don't stop with this act. The act is loaded with a lot of amendments on the CPC, and that is more important. Yes. 35 is we all very happily, I mean, accept this particular section because 35A item. I would read it for you, in fact. It's a big section. 35, unfortunately, original 35 is totally substituted by a new 35. The old 35 was a very, very small section. What 35 said was only so much. The old section read it this way, in fact. Cost, subject to such conditions and limitations as may be prescribed and the provisions of any law for the time being in force, the cost and the incident, cost of and incident to all suits shall be in the discretion of the court. That's all. And the court shall have full power to determine by whom or out of what property and to what extent such costs are to be paid, and to give all necessary directions for the purposes aforesaid. The fact that the court has no jurisdiction to try the suit shall be no bar to the exercise of such powers. So even when ultimately it is found that the court has no jurisdiction, still the court would have the authority to grant a cost. Where the court directs that any cost shall not follow the event, the court shall state the reasons. So by default, the rule is that whenever there is a civil proceeding, a decision must have come in favor of somebody and a decision has gone against somebody, in which case the cost has to be imposed on the person who has lost the case. Because he did not have a good case, he should have conceded to the courts or the claim, and so conceded to the court or the other one's claim at an earlier stage and should not have wasted the court's time or the other parties. So this is the general concept. Now this 35 has been amended to include so many things which is very, very relevant. In relation to any commercial dispute, the court, notwithstanding anything contained in any other law for the time being in force or rule, has the discretion to determine what all, whether costs are payable by one party to another. So whether the costs are payable in this particular case, is it a fit case for giving cost? The quantum of those costs, how much is, if costs are payable, then what cost or what is the quantification? The next one, when are they supposed to be paid? Now this is the first part of subsection 1 of 35. So whether it should be paid, how much has to be paid, and when they are supposed to be paid. The next one is, for the purpose of clause A, that is the expression of cost, it shall mean reasonable cost relating to, there are 3 things to be looked into. The fees and expenses of witnesses incurred. So all the process, all the expenses, TA, DA, all that has been given to the witnesses becomes a cost. Had one party avoided this genuinely by conceding a true fact, this would not have been necessary. Therefore, the person who has contested unnecessarily, frivolously, or vexatiously is bound to give the cost. This is the principle. Then, the fees and expenses of the witnesses. The next one, legal fees and expenses incurred. All the other expenses, the lawyer's fees and all those. Then, any other expenses incurred in connection with the proceedings. The third one, which could be so many. Now, if somebody loses, even if he could be imposed with the cost of the mediation which the other party had to pay or both the parties had to pay. So if 15,000 is the cost of mediation and one party has paid 7,500 and he has ultimately won, and the other man has misconducted or he has not conducted fairly before the court, the court can even give that kind of a cost, or the 7,500 which the other person was made to spend without any use. Now, even to such an extent, the explanation goes as to what can be. Now, 2, if the court decides to make an order for payment of costs, the general rule is that the unsuccessful party shall be ordered to pay the cost of the successful party. That's the general rule. And for which purposes the clause 1, the other 3 criteria, then the second 3 criteria can be looked into. Generally to see whether how much the losing party is supposed to give. Kind of clear. Provided that, very interesting, provided that the court may make an order deviating from the general rule for reasons to be recorded in writing. Beautiful illustration is also given wherein the plaintiff won his case, but he was asked to pay cost to the defendant. Very interesting. I'll just explain it in short. I put a claim of 10 lakhs as against Mr. X. Mr. X takes a contention very fairly that, sir, I am supposed to, I am liable for 7 lakh rupees. But there is a 3 lakh adjustment which the plaintiff should have looked into, and you should have deducted and you should have claimed only 4 lakhs. Now, commercial court, you are supposed to explain. This അത്രയും ക്ലാരിറ്റിയോട് കൂടിയും ഓരോ ചെറിയ കാര്യങ്ങളും ഡീറ്റെയിൽഡ് ആയി ഡിസ്ക്രൈബ് ചെയ്തോളെന്നാണ് ഇതിനകത്ത് അമെൻമെന്റ്സ് പറയുന്നത്. Even if I am not in a position to complete the whole of the CPC, wherever there are amendments, this is how the whole gist of it goes. So he says, yes, 7 lakhs is my liability. I do not admit the liability of 10 lakhs. Then how much? 7 lakhs is the liability. He has to specifically say. Then he says how much he is liable to pay. He can take all the defenses. I am entitled to 3 lakhs adjustment because I had actually given an advance, which is accountant as not. I had pointed it out. They say their account doesn't show that. I have proof of this. That one. Then he could have made a claim only for 4 lakhs. And I was ready to give this even much earlier. But he did not accept it. That is next part of it. And the other 3 lakhs which he has claimed in excess is absolutely frivolous. It is bad and I cannot grant it. The court may not grant it also. Now at this point, the court would ask a question. There is a provision which says, the court would ask, do you accept any of these proposals to the defendants? To the plaintiff. Plaintiff says no. Plaintiff says no. I am ready to accept the 4 lakhs, but I will still contest for the 3. And if he is ready to accept this, and if the defendant shows his willingness to pay 4 lakhs, that would be noted by the party. Very interestingly, what would be seen is, at the end of the day, the court would grant a decree after finding whether the 3 lakhs that he has asked for adjustment is correct, and if it is found correct, excellent, 1 mark is given to the defendant. And if the plaintiff fails to prove the remaining 3 lakhs, which the defendant says is frivolous, he will hold it against. Interestingly, 4 lakhs as conceded, he has not disputed. Therefore, the whole cost even could be tilted to the extent of cost being given by the plaintiff to the defendant for so many reasons. 1, a proper offer was not accepted, and that was unfair of him. Defendant has come out with a neat proposal, which I find was ultimately on evidence correct. Defendant has raised a frivolous claim. All these are grounds for granting cost to or imposing cost on the plaintiff to be given to the defendant. And the conduct of the plaintiff would be looked in as absolutely frivolous, vexatious, and a misconduct. Now we'll see, there are provisions which says it can be given. The example, I'm not reading it because you will certainly get the illustration, and that would be a different example for that purpose. But that's a case where the defendant gets a decree, but he is asked to pay the cost to the defendant for similar kind of reasons. Now, then we have 3 introduced. In making an order for the payment of costs, the court have, now I may in between, before I forget, or if before the session goes off, let me just give you one hint, probably again that would be a take home for you. Most of us, when we prepare our cost memo, claim all these expenses, witness bata, matte marche ellam andana claim cheyum. Advocates fee, schedule prakaram claim cheyum. But there is just one fee which I have noticed that most of us have not been claiming for a long time. And as and when I had made claims in the earlier stages, the judge also used to dismiss, saying that, how can I give you this? Now, for your information, there's a rule 36 in the civil rules of practice relating to fees payable to the advocates. Please take a note of this. Rule 36 relating to the rules relating to fees payable to the advocate. There's something called days cost. Now, if you apply for this, probably the more the number of postings you would be entitled to get, and especially in commercial court being a sub-court, a minimum of 1,500 rupees. So if there are 40 postings, you would be entitled to get so many days cost. And this is mandatory to be given if cost is allowed. Just a cue for you to apply next time. Tell your clerk also to note this and make a column for this in the cost memo. And it is being allowed nowadays. Of course, after arguing so much before the judges, they have started giving it to all the lawyers also. Now, let us see Rule 3. In making an order for the payment of costs, the court shall have regard to the following circumstances, including the conduct of the parties, whether a party has succeeded on part of his case, even if that party has not been wholly successful. 1. Whether the party had made a frivolous counterclaim leading to delay in the disposal of the case. Whether any reasonable offer to settle is made by a party and unreasonably refused by the other party. Whether the party had made a frivolous claim and instituted a vexatious proceeding, wasting the time of the court. Next one. So these are the criteria for best practices, good behavior, good conduct, and misconduct. The word used is frivolous and vexatious. So these are stages, at different stages, you could certainly win over the court and you could win over the cost also for the party. 4. The orders which the court may make under the provisions include an order that a party must pay a portion of another party's cost, a stated amount in respect of another party's cost from and until a certain date. This could be based on performance also. Costs incurred before the proceedings have begun. Now, I told a little earlier that you can even ask the other party to pay the mediation cost if things could have been settled and he had not been responsible when he was appearing before this thing, or he did not appear at all. He came for one day. Next day onwards, without information, he has left the mediation. On the contrary, he has not contributed to the process. He did not save the court's time. This is what exactly the whole scheme of this is. Costs relating to particular steps taken in the proceedings. Now, what are the steps? Order 11. My friends, please go through Order 11, Order 12. These are the best keys, the best of the tools when you conduct a trial. Now, all these are stages where you can win over each of these stage costs. Costs relating to a distinct part of the proceeding and interest on costs from or until a certain date. Now, very interestingly, you even get interest on cost, which was not there in the earlier stages. So this law says, okay, after having a decree, and if you don't pay even cost, which actually the other man has spent, you are entitled to pay interest on that cost because the other man has suffered that much finance. Let us take the next one. 35A. Even the old 35A relates to compensatory costs. Now, when compensatory costs is being granted, there was a hitch. It used to have an upper limit of 3,000 or the jurisdictional amount that the court can. That limit has been taken away under this. That means even as compensatory costs, the court can issue or grant an order of cost to suit the situation. Then the next one is now we'll take Order 5. I just browse through this. Order 5 speaks about a sentence in a summons. What does the summons say? Summons says that you shall file a written statement within 30 days. Now it will also say that if it is not filed within such time, a maximum period, if so permitted by the court, that being 120 days, your written statement will not be accepted at all. It is even incorporated in Order 5. So also under Order 8 as amended. So this is something which we will have to keep in track. The next one is Order 5. After Order 5, Order 6. Order 6 is forms of pleadings. This is where I mentioned that most of us, though we have our own standard formats which we have developed with our expertise in our standards in English, or what we have seen or learned from our seniors or from the neighbors or from the copies which somebody was generous to give us. But we don't have to go anywhere else. We have the best of the guide in Appendix A. So Order 6 speaks about, Order 6 Rule 3 especially, says that whenever a plaint is to be or a pleading is to be prepared, such pleading shall be in the form provided in Appendix A(1). And if no specific direct form is not given, as an example in Appendix A, then you shall use any of the forms which are closer and suitably make modifications and then do it. But however, forms are mandatory. You're supposed to comply with Appendix A. It is not merely a guidance. Now, Appendix A, if you would check, it has nearly 50 forms. Suit for money, suit for mortgage, suit for injunction, suit on tortious claim, suit on that, suit on negotiable. Everything has been given under that. So what more is required? We can certainly follow that. Now, commercial court insists on one more thing. If in the future High Court provides for certain formats to suit its courts, then you may also follow such forms as may be prescribed in the future under this Act for the purposes of claims under this. Now, certain new things are to be pleaded in this commercial. When you go through that, you will certainly look at it. There's so many new things. When it comes to Order 8, which has been amended, lots of new things will have to be mentioned. So the old forms of 1908 may not contain all that specifically, and therefore, this would certainly, the forms would certainly be formulated by the High Court, and it may be appended, or at least under the civil rules of practice, in which case those would also have to be looked into. This is what the amendment in Order 6 says. And that has been brought in as 3A. And it also says there are two modifications which have been brought in. One is 15A. Now, 15A is a format that I had mentioned when the affidavit was introduced. 15A says verification of pleadings in a commercial dispute. Notwithstanding anything contained in Rule 15, every pleading in a commercial dispute shall be verified by an affidavit, as has been mentioned earlier. Affidavit in the manner and form prescribed in the appendix to this schedule. So that affidavit will have to, the verification will have to be as in the form of in addition to what has been mentioned in 15. 15A says there has to be subsequent verification by way of an affidavit with all those clauses. And that is what they have repeatedly mentioned here. Now, how it shall be, the details as to how it should be and all that, it should be very easy. It's as good as a civil rule. Now it says, orders in plaint, there are some additions which are being given. Now, every commercial dispute would certainly have a monetary element. Now, when it has a monetary element, it certainly involves payment, etc., etc. Whenever there is a payment of money, a delayed payment of certain principal amount would certainly attract the interest component. Now, being commercial dispute and more so related to monetary, they thought that there has to be a specific pleading as to the interest also. Now, we have noticed in 34, section 34 of the CPC, that interest could be different. Default interest is 6%. And if it is a commercial issue, commercial transaction, the interest could be the contractual interest or the agreed. This is what they say. Now, to make it more significant in this, what they have done is they have incorporated Rule 2A after Rule 2. in order 7. What does it say? Where the plaintiff seeks interest, the plaint shall contain a statement to that effect, along with the details set out in subrules 2 and 3. And the 2 and 3 reads this way. Where the plaintiff seeks interest, the plaintiff shall state whether the plaintiff is seeking interest in relation to a commercial transaction. 1. Why? Because there could be a civil transaction. So also, okay. Yeah, I have noted that, Pramod. Now, it says, if it is a commercial court, there would generally be a question, why should it say that it has it relates to a commercial, this one, the suit relates to and the interest is relating to commercial transaction? Yes, it is very relevant, though we might miss it. A civil suit in which a counterclaim has been raised with respect to a commercial transaction, this would certainly come to this. That's what we mentioned. So there could be non-commercial issues also. Where in a commercial transaction, if somebody brings in a civil counterclaim, which has nothing to do with this, he can raise a counterclaim. So there could be a mixed, claim, a mixture of, a claim which is relating to commercial and one which is not relating to commercial. Therefore, wherever it is commercial, the judge should know. So that is why it specifically says in relation to a commercial transaction within the meaning of section 34 of the Code of Civil Procedure. This is to enable that. Now, and furthermore, if the plaintiff is doing so under the terms of a contract or under an act in which the case act, there are two ways. There could be a statutory interest. Now, let us take a case of negotiable instruments. A suit on negotiable instruments. The statutory interest prescribed under the Negotiable Instruments Act is 18% if the money due or if the suit is based on a negotiable instrument. Therefore, there could be other statutes. Now, when the interest is prescribed under a particular statute, then you will have to mention whether it is a statutory interest or it is a contractual interest in the sense that you have agreed to that in any of the agreements that you have. Certainly, the banking and all that. The only check would be the usurious loans and other, statutes which probably would control any of this. So it speaks about that. Now, 3, pleading shall also state, that's a sub-rule, the rate at which the interest is claimed, then the date from which it is claimed. So there could be an agreement where there is a default agreement, a default clause, wherein under section 74 you would have certainly mentioned a term or more in the way of a, it speaks about liquidated damages and other things, wherein you can. Yes. So we'll continue. Now, pleadings shall also state these things. One is the rate at which the interest is claimed, the date from which it is claimed, the date to which it is calculated, the total amount of interest claimed to the date of calculation, etc. So all these could depend on a contract that we have formulated. And the contract probably would take in a stipulation under section 74 of the Contract Act. Now, this is probably one of the situations that the lawmakers have contemplated. Now, until recently, we never used to think of all these things. Now, they are much more concentrating. They are looking into all those aspects which would be relevant to a commercial dispute being decided. Now, after this, so with respect to plaint, that is the only thing that they have mentioned. Now, when we come to Order 8, very, very important. A very seasoned lawyer would appreciate this. Because if such is the way in which a written statement is filed, then half the fight would be concluded or closed by a decent written statement, a fair written statement. So therefore, they say there are so many things that we expect you to just you let execute. Yes, Satyam. sorry, there's a warning. So I'll just rush through. In fact, see, Section 8 speaks about, in short, how much can I admit or how much do I admit? What I will not admit, what I cannot admit, and what I would deny and why I deny. So these are the reasons. These are the ways in which you will have to look into. So if somebody, the earlier example that I mentioned, a claim of 12 lakhs or 10 lakhs, I fairly admit what is otherwise due. You don't now have to wait for him to prove. And if it is proved by him, the court will certainly have an eye on you. If this was the situation, if these were the documents, you should have, might as well, admitted at the earlier stage. Now, what is happening today is basically, it is fishing. Let him prove it. Until then, let us see if he can prove it. Now, when you go through further, this doesn't happen at all. Let us see how everything is placed before somebody. It is exactly like once you are in the box and if you are shown a document, either you will have to admit or you may not admit. And if you don't admit, if the court accepts it, then you are literally a cheap character before the court. You are not acceptable to a court. Now you are shown all these documents in a commercial court. You are shown all this well in advance, mandatory. And you are supposed to say all this even much before the trial in writing. That is the kind of process. So when you write a written statement, you already have all the materials in front of you. Going by the commercial court and the CPC, which we could have done it earlier, we were not doing it. So now they have made it mandatory so that you learn to do it, even without, asking you to do it. You are bound to, otherwise you face the consequence. This is how it has come in. So when you plead, you are supposed to take such clear pleadings where whatever you can admit, you are supposed to admit. And whatever the plaintiff knew earlier that you would not make it, he is not expected to raise. If you don't admit, even if you partly admit something, why you cannot? And if it is a figure, you are supposed to say, if you deny so much, then how much do you admit? Or when you deny something, why do you deny it? And when you say why you deny it, you are also expected to give your version clearly. It is that version which would actually give a justification, and the judge should get the justification at the initial stage itself. Now, I am not talking this purely because it has come into the commercial courts. All these are even otherwise available in the CPC. That's all I'm going to say. But it's in a subsequent provision. So Order 8 is a warning to you as to how you should write to avoid a cost to the court. I'm sorry, cost to the party. Let's just take this. 3A. After 3, earlier 3, we are just going to add this 3A. Denial by the defendant in suits before the commercial division of the High Court and the commercial court. So since they mentioned commercial court, forget about the High Court, which is meant for the 5 states. And for us, it is the second part. Denial shall be in the manner prescribed under subrules 2, 3, 4 of the, 2, 3, 4, 5. The defendant in his written statement shall state, now 2, 3, we'll read from 2 to 5, and that will give you a clear picture. In his written statement shall state which of the allegations in the particulars of the plaintiff he denies, which allegations he is unable to admit or deny. In Order 12, if you give a notice to admit, how do you answer that particular notice to admit under Order 12? 2. It is exactly the same way. Now, how much he denies and why, allegations the particular plaintiff denies, which allegations he is unable to admit or deny, but which he requires the plaintiff to prove, and which allegations he admits. Casual. It is not admitted. The plaintiff is put to strict proof. It's just a casual way of putting it. Now it is a statutory one, and for using each of these words, there's a reason why you are doing it, because you don't know. You cannot say very specifically. Where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so. And if he intends to put forward a different version of events from that given by the plaintiff, he must state his own version if he denies. If the defendant disputes the jurisdiction of the court, he must state the reasons for doing so. And if he is able to give his own statement as to which court, that means yet another responsibility is given. It's not merely that this court will not have jurisdiction, does not have jurisdiction. Then you should have a clear picture as to this. A suit would certainly go to a particular court with jurisdiction. And he should name that also. Now, this is how it has been given. Provided further that every allegation of fact in the plaint, if not denied in the manner provided under Rule 3A, earlier one, of this order, shall be taken to be admitted except as against a person under disability. What else? No court shall make an order to extend the time provided under Rule 1, which being 120 days, 30 days, extendable by 90 days. Now let us see. There's always a question as to how we are going to prepare such a written statement. Now, written statement, you get up to 120 days. Now, you don't know how many materials are there. The rest of the provision says how to make the other party get all the documents, all the details before you and before the court so that you can even peruse it through the court. Order 11, title Order 11 has been totally, it is basically substituted with a smaller Order 7, but with a much stricter. The Sada police ne maatittu pattaalathine irakki parna poleyanu. 50 പോലീസുകാർക്ക് വരാം 5 പട്ടാളക്കാരെ കൊണ്ടു നിർത്തി തോക്കും എല്ലാം വെച്ചിട്ട് അതുപോലെയാണ് ഈ 7 ഇത് വന്നിരിക്കുന്നത്. But a very elaborate disclosure and discovery of documents. My friends, I mean, anything that is any application, all these, we don't have much trouble at all. You can just go to Appendix C. There is a form for each of these things. You just fill in things, fill in the blanks and submit it. It is so simple. The other man would be ordered to get things that he has to you. Disclosure, you are supposed to disclose. Discovery or opening up, recovering what is otherwise covered and kept. Now, if there is something mentioned in the plaint or any of the pleadings or anywhere, even in a document, you can ask those particular documents for inspection at the other person's, wherever, whichever is convenient to you. You can ask for inspection of those documents in his custody or in anybody's custody for the matter. Now you go and inspect, and if you feel that this is relevant, you can ask this to be produced. So there's a provision for production of documents also. So this gives you all these kind of, all these kinds of techniques whereby before you make a written statement, draft a written statement, all these can be utilized. Interrogatories, of course, we all know. Interrogatory is also yet another one. You can put a question, get that information. So any information that you need before you when filing a written statement, Order 11 provides for it. Any document you would like to refer, he provides it. If you want to rely on that, he will provide it. Now you can also insist on one thing, that look, the other side cannot take me by surprise. So you can put an application even under 105 and 106. These are the two provisions under the civil rules of practice which are relevant to this. You can still use them or under this. Now Order 11 Rule 12 is a provision whereby you can ask the other person to produce all those documents. And if you do not know what are the documents, what secret documents would be there, you make an application asking him to disclose all those documents he has or he intends to rely on in a trial. This application can be made under Rule 105 or 106. So he will have to place all. If he doesn't bring this, if he doesn't disclose or if he doesn't produce this, he cannot be permitted to rely on those documents. Now you cannot take. So this is the kind of transparency that we face in a trial. Now discovery is that. All these are very strict ones. So I only wanted to tell you that please go through Order 11, which gives you excellent tools. The other man is compelled to force to bring everything that you will require. And he cannot, he will be totally exposed. So once you have all these kind of things, what prevents you from writing a decent written statement? Now, similar is the case with Order 13. We already have Order 13. Hello?
Yes, sir.
Okay. Is it okay? Can you hear me?
It's okay. It's okay.
No, Pramod, I don't know about the time constraints. I don't know if the members would like to continue, or I can spare another few minutes and then finish off.
Yeah, you can continue. Can you share how much time it will take?
I'll do one thing. I'll conclude the whole thing in about less than 5-10 minutes. I'll just browse through fast.
Okay, then. Okay, no problem. Okay, sir.
Okay, fine. Okay. Because I'm not touching CPC, but let me at least touch something important.
Okay.
Yeah, fine. Thank you. Now, after 11, when you discover everything and once you get all these produced, you have order 12. Before you admit something, you will also have a right to know how much he admits of your case. So under order 12, which is seldom used, very rarely used by our lawyers, unfortunately, you can file an application under order 12 rule 2, which is not in this. Probably you may not find it, Pramod.
Yes.
Okay.
Okay, sir.
Now, you can file, even now, you can file an application under order 12 rule 2. It says that you can ask the other side to admit the document that you produce, so that you are very sure that you don't need a witness to be summoned once he admits this particular document. Excuse me. Sorry. Now, that is what order 12 is. Now, there are 3 things that you can get admitted from the other person. You can get your case admitted. You put in a particular sentence or 4 sentences that you and I were partners, or you are a trader and I am one of your franchisee. Fine. You had issued certain things to me, towards which I had issued certain things to you, and in consideration you had given me a check. There are 3 transactions. You put this one by one. Sentence 1, that the plaintiff and the defendants were in commercial transactions. 2, plaintiff supplied goods to him. 3, the defendant issued a check. These 3 are facts. Write these and say, issue a notice to the other side through the court and say that the court ordered the other person to admit these facts. Now, this would even be a case if you add a couple of things more. What is that? That the check got dishonored. You gave me only 50% thereafter. The 50% is remaining. And on this, you are supposed to give me the money, or so much is liable, and this is the interest that we had agreed to. If these facts are proved, the court has no fact to be literally discovered or proved. He doesn't have to adjudicate on these. These are admitted ones. Now, once you give this kind of a notice, the other person admits it. You can easily, even the written, once you give this kind of notices, these would become admissions under order 12 rule 1. And if a fact is admitted, you are even entitled to a decree under order 12 rule 6. All these are incorporated even now. What does it say? Every document that has been placed before the court for the perusal of the opposite side shall look into it, examine it, and he is expected to file a statement of admission. That is what rule 4 additionally has been brought in. This was not available in the earlier CPC. Now, when it comes to a commercial court adjudicating a commercial dispute, there has to be an admission or admission and denial of documents. So, which means you are very clear which of the documents will have to be proved or will be subject to proof. And if 5 documents are proved, let's assume there are 5 checks. He admits 4. The 5th is not. 5th you say, okay, it's a 2001. For the easier closure of the suit, I am ready to waive. On the admissions, let there be a decree. You are not being frivolous to the court. You have produced a check which is dishonored, etc. Court would only appreciate it as you have saved the court's time. So use these techniques of admissions. And now this has been mandatory. So there is a posting for statement of admissions. Now what does it say? each party shall submit a statement of admissions or denials of all documents disclosed. Disclosed means it's a disclosure. I have produced mine, which means it's a disclosure. On request, he has discovered it. That means I have disclosed again. So documents disclosed and of which inspection has been completed within 15 days of the completion of inspection and, or any later date as fixed by the court. The statement of admissions and denials shall be set out explicitly whether such party was admitting or denying correctness and contents of documents, existence of a document, execution of a document, insurance of receipt of a document, custody of the document, etc., etc. Now, this talks about documents. Similar is the case with a case, or you just want to prove only one particular fact in a partition suit, or let's say in a partnership. Whether you are a partner, if the denial is as to the partnership or whatever in the notice, you only ask a question. Am I not a partner as per this particular registered deed, and subsequent documents are never registered? If he gives an answer, half your case is proved. So Order 12 gives you all this. So exploiting Order 1, the various techniques in Order 11 and Order 12, you can certainly prepare a decent written statement and do the working. Interestingly, all these will have to be complied within 10 days, 15 days, 7 days, etc. You have 120 days. If you have 120 days, along with the plaintiff, you can proceed with this, so that the defendant will not have a chance except to admit. Now, when defendant wants to write a decent, and if he has a good contention, you can also start. The moment you get the summons, you get 120 days within which you can exploit all these techniques as against the plaintiff. And in a commercial court, as is normally done in Delhi and all, because they're seasoned with this kind of procedures, they inevitably order this. You can also use the interrogatories. At the end of these two, there is nothing probably left out. The judge will only have to say, this fact raised by him is admitted, this is not admitted. So with which, what I'm saying, so this is a fair practice that they expect under the new one. I have just summarized it, please don't conclude it, or just take this as conclusive. If you can go through 11, 12, then rest everything is perfectly fine. There's not much. There are two procedures which are introduced. One is summary judgment. You may just have a note of it. Order 13A speaks about summary judgment. Very interesting. It looks as if we did not have that kind of a concept. We always had that kind of a concept. You can, Order 13A is similar to that of Order 15 as it stood in the original CPC. I'm sorry to say, because I have applied Order 15 to get the same kind of an effect. Order 15, the heading itself is disposal of the suit on the first day of hearing. Happiest moment in the judge. First day, appear in the there are lots of other sections, so Order 10, Order 40. Because it doesn't come within this. Had it been a CPC class, things would have been different. Now, Order 13 speaks about summary judgment. On the basis of materials available, if the judge feels, and the parties also say, that there is no further facts to be proved, or a judgment on the facts which are already available, material available can be given to us. In the Paranya, the court can immediately grant a judgment. What is required to be looked into is on the admitted pleadings and on the admitted documents. What is the relief that the court can grant? Or what is the kind of an order that the court can? This is what is, in sum and substance, this is what is the summary judgment. Only thing that he has to do is, what is the law applicable in the facts and circumstances of the case? This apply and then Order 15 Pandu undairunna. Specific, they have given a provision, that's all. Now they have also introduced something called the case management. This case management actually comes from a Supreme Court judgment where, you all must be remembering, in fact, must be in 2013 or so, where a Supreme Court judge really, annoyed with a delay in certain matters. He gave a lot of guidelines as to a timetable to be set by a civil judge as to when the written statement or when the issues to be, when the all the other steps to be taken, then when Order 11 is to be complied with, when Order 12, and when are the issues to be framed, when would you have the pre-trial steps completed. So within a 6 months time, he would have all those things, set up, which means you are given a warning as to this is what I am going to look at. I'm giving you this particular timetable much in advance. This used to be a practice. Now, case management hearing is nothing but scheduling as we have the scheduling in criminal trials. He will hold a case management hearing, like you have the defense lawyers and the prosecutor, and asking how many witnesses, what is the situation, how much time will you take, what is the extent, what is the complexity involved, and he would fix a schedule of the things that the judge will have to do. A very, very detailed case management. Now, this is normally done. I'll just read the first point. The court shall hold. You will find this in 15A. Very interestingly, 15 is deleted. I do not know. 15 is a wonderful provision. Maybe with 13A, newly introduced 15 will not have relevance. Now, instead of which they have brought in 15A, which it is entitled as case management hearing. The court shall hold the first case management hearing not later than 4 weeks from the date of filing of affidavit of admission. I mentioned about the rule for affidavit of admissions. Once that particular stage is over, then the court will look into the case management process. So it is within so much time that they will have to do this. Then admission or denials of documents by all parties to a suit. In a case management hearing, after hearing the parties and once it finds that there are issues of facts and law which require to be tried, the court may pass an order of so many things. Ororo stage narrate case management. It's basically managing the time frame. What is to be done when. Now, interestingly, the order 15 rule 2 speaks about a condition. In a case management hearing, after hearing the parties and once it finds that there are issues of facts and law which require to be tried. Tried means proved in a court of law. If not, somebody can apply for a summary judgment. But summary judgment, what I mentioned in 13A, has to be on the basis of an application. And the process is so cumbersome that most of us will find it not interesting to do that. We would rather say order 15 was much better, which was a very simple one. We would say both sides agree on this and can be no oral evidence. In the Parani, it has become very cumbersome, lots of documentation, etc. Now, when it is not possible, the court would look into the next part of it. That is, yes, this has to be tried. Then we know it is order 16, etc. 16 means order 16, all summons to the witnesses, etc., has to be. Now, that is how the whole thing goes in. Then, there is a little restriction and regulation on order 18. Order 18 is what we normally understand as the trial. That is, list ചെയ്തിട്ടുള്ള ദിവസം നടക്കുന്ന കാര്യങ്ങളൊക്കെയാണ് order 18 പറയുന്നത്. I would be totally unhappy to discuss it in a lighter mode, because if you analyze order 18, we will sit for a day as experienced lawyers and then we will enjoy order 18, the whole of CPC. For order 18 also, they have restricted it as to how the evidence should be. But one critical thing that I'm sure you all would be going it in detail. Some different thing that has come in is an argument note is mandatory, which has to be filed 1 month before, 30 days prior to the date on which the final hearing is posted, after the evidence. Now, evidence has to be by way of affidavit. Affidavit has to be as in, order 19. The difference would be plaintiff's affidavit would be different from the witness affidavit. The wordings will have to be different. And there are these kind of, slight modifications that have been brought in under order 19, order 18, etc. and the decree, etc. So this is the sum and substance. I'm sorry to say that I took a little extra time. This is the sum and substance of Commercial Courts Act, which has now come in. All of us are supposed to experiment it. I have seen this when I studied, because certain courts had this practice even much earlier. This was a practice which was followed in the Presidency Court. So when I used to do my internship in Bombay courts, I have seen this. So this is not totally new to me. Now, if our duplicate കൊടുക്കണ പോലെയാണ് അവിടെയൊക്കെ plaint കൊടുക്കണേ. Henceforth, that is the way the plaint would be filed in commercial courts also. In the sense, you will have to attach a copy of all the documents to the plaint and then produce a copy for the other side. And it is those documents which you will have to admit or deny in the statement. Unless we also apply for production of further documents. The defendant applies for further documents or either party applies for disclosure and discovery of further documents, etc. Now, I know this is not a holistic approach narrating a particular statute, but I am sure that now we have a fair idea as to there is something to be looked into this particular statute, if at all we are actually planning to go into this. We have some time to relax for the simple reason that all our commercial matter will have to get transferred. And then they would also take some time to get it organized. And even the judges are yet to be trained. The academy has not started its training part also. Though people have been appointed as principal sub-judges, some of them are transferred, etc., etc. All of them have started facing this issue. Pramod, I think I can I stop at this stage?
Oh, okay. I think
I know
a little yeah.
I know I'm keeping people late. Adondana. One session for me, it's okay.
Let us ask the participants. Please give in the chat box whether
I may not
any
be able
questions or whether a 10 minutes time can also be spared or not.
This is the sum and substance.
Okay.
Everything else still have to be gone in detail. In detail had to go on.
Okay.
Unless we have a detailed session at a different point of time with what was earlier and what is new. അങ്ങനെ നോക്കി എവിടേക്കാണ് ആഡ് ചെയ്തിരിക്കുന്നത് നോക്കി ഹോളിസ്റ്റിക് ആയിട്ട് നോക്കുകയാണെങ്കിൽ it's well and good. But if not, it is better that I stop here because 18 takes considerably long time. And all of us are seasoned civil trial lawyers, so we will certainly, when you read it also, we will compare it.
Okay, sir. Okay. എന്തെങ്കിലും doubts ഉണ്ടെന്നുണ്ടെങ്കിൽ chat boxil post ചെയ്യാം. There is one question, sir. Does this act house the jurisdiction of district court in intellectual property enactments? Seeking the clarification.
Section 11. ഞാൻ provision വെച്ച് പറയാം because all of us will have to argue this before the court if at all it is transferred. By any reason a district judge transfers it, we will certainly have to argue this. So section 11 എടുത്തു കഴിഞ്ഞാൽ കാണാൻ പറ്റും. Can we look at it? And I'll go through it also if for people who don't have the section 11 on the damo post ചെയ്യാമോ? Same ഇതില്?
Okay, sir.
Section 11 മറ്റേ ഇതിനാ വരിക കേട്ടോ.
Commercial court.
PDF ൽ ഉണ്ടാവും. PDF ൽ. എല്ലാം ഞാൻ ഫുൾ ടെക്സ്റ്റ് തന്നിട്ടുണ്ട് അതിനകത്ത്. Yes. ഒന്ന് വലുതാക്കാൻ പറ്റും. Okay. Now, where is the bar on the commercial court itself? Which means what otherwise a commercial court would get. It is supposed to go to anything which is commercial, it by default should go. It should by default, it should go to, it's the privilege of the commercial court as it thinks. Now, interestingly, there is a bar imposed on the jurisdiction of the commercial court itself under section 11. So, which means otherwise, but for this bar, you would have been able to hear it. What is the bar? Notwithstanding anything contained in this act, okay, is a doubt as to where exactly what is the provision? അതാണോ മറ്റേ ആക്ടിൽ എവിടെയാ കാണുകയെന്നുള്ളതാണോ?
അത് മാത്രമല്ല സാറേ,
ഞാൻ പറഞ്ഞുതരാം ഒരു ഉദാഹരണത്തിന്. If you can check 142 of the, if I'm not mistaken, I think it's 142 of the Patent Act. എന്റെ ഓർമ്മയില് 4 സ്റ്റാറ്റ്യൂട്ടിലും വെച്ച് ഒന്ന് 72, ഒന്ന് 142, അങ്ങനെയൊക്കെയാണ് ഇതിനകത്ത് കിടക്കുന്നത്. ഓരോ ആക്ട് എടുത്താലും, ഡിസൈൻസ് ആക്ട് എടുത്താലും, മറ്റേ ട്രേഡ് മാർക്ക് ആക്ട് എടുത്താലും എല്ലാറ്റിലും if you can look at jurisdiction in the court in the jurisdiction, the last towards the end ആണ് എല്ലാറ്റിലും ഉണ്ടാവുക. എടുത്തു കഴിഞ്ഞാൽ 163 അങ്ങനെ നോക്കി കഴിഞ്ഞാൽ പറയുന്നുണ്ട് any dispute arising out of this relating to trademark അല്ലെങ്കിൽ ഇത് ഓരോ സ്റ്റാറ്റ്യൂട്ടിലും പറയുന്നുണ്ട് under this particular statute with respect to the inter se rights between the parties, not what should go to the tribunal. There are some matters which should go to the tribunal. അതിന് റിസർവ് ചെയ്തിട്ട് എല്ലാ ട്രൈബ്യൂണലിലും പോകണ്ട. പാസിംഗ് ഓഫ് ഇസ് വൺ തിങ്. which still is being tried by a district judge, a civil court.
Section 15 is silent regarding transfer. Doubt
Oh, I say, 15 speaks about, I'll just take 2 minutes. Section 15 speaks about transfer of all pending cases which qualify to be a commercial dispute to be decided by a commercial court. And the valuation 3 ലക്ഷത്തിന് മീതെ ഉള്ളതും എന്നാൽ 2C വരുന്ന 2C 1 to 22 വരെ അല്ലെങ്കിൽ നോട്ടിഫൈഡ് ആയിട്ടുള്ള വല്ലുണ്ടെങ്കിൽ അതുവരെ വരുന്ന ആ സബ്ജക്റ്റിനകത്ത് വരുന്നതുമായിട്ടുള്ള മാറ്റേഴ്സ് എല്ലാം തന്നെ they have to go to the commercial court. അതാണ് 15 ട്രാൻസ്ഫർ. അതെങ്ങനെയെങ്കിലും മുനിസിപ്പൽ കോടതിയിലോ സബ് കോടതിയിലോ എവിടെയെങ്കിലും കിടപ്പുണ്ടെങ്കിൽ അതെല്ലാം തന്നെ ഇങ്ങോട്ട് വന്നിരിക്കണം. ഈവൻ ഡിസ്ട്രിക്ട് കോർട്ടിലാണെങ്കിലും ആർബിട്രേഷൻ്റെ ഒക്കെ പറഞ്ഞ പോലെ they all should automatically get transferred effective from 24 February or 25 February എന്നാണ് പറഞ്ഞത്. Now, അങ്ങനെ ട്രാൻസ്ഫർ ചെയ്യുമ്പോൾ നമുക്ക് ഉറപ്പായി ഇതൊക്കെ ഒറ്റ നോട്ടത്തിൽ ഇതല്ലേ ട്രേഡ് മാർക്ക് 17 2C 17 ആയിട്ട് കാണുന്നതാണ് ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി എല്ലാം. പക്ഷേ ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടീസ് ഇൻവോൾവ് ചെയ്യുന്ന 4 സ്റ്റാറ്റ്യൂട്ടിലും ഒരു കാര്യം പറയുന്നുണ്ട്. That any matter, any dispute arising on the subjects covered by this statute shall be decided only by a judge who is not below the status of a level of a district judge. Angana varumbo there is a specific bar under that. Now the question would be, what is a special statute? Idokke mootiyanalla. What is this? കാരണം ഇതുവരെ ഈ ക്വസ്റ്റ്യൻ വന്നിട്ടില്ല. എന്താ കാരണം എന്ന് വെച്ചാൽ ഇതുവരെ ഇതെല്ലാം ഉണ്ടായിരുന്നത് 5 സ്ഥലങ്ങളും ഡിസ്ട്രിക്ട് ജഡ്ജാണ് അവിടെ കൊമേഴ്ഷ്യൽ കോർട്ട് ഉണ്ടായിരുന്നത്. അപ്പൊ അവർക്ക് ഈ ഒരു ബാർ വരില്ല. നമ്മളെ സംബന്ധിച്ചുള്ള അത് വരും. Where sub court is being appointed as the commercial court. ഈ ബാർ വരും. കാരണം what is a special? This is only a procedural provision. Procedural provision with respect to commercial disputes in general. Now, when it comes to intellectual property, that is a special statute by itself in substance. അതിനകത്തുള്ള എന്തോ ഒരു കോംപ്ലക്സിറ്റി ഉള്ളതുകൊണ്ടായിരിക്കണം ആ ടൈപ്പ് ഓഫ് മാറ്റേഴ്സ് വിൽ ഹാവ് ടു ബി ഡിസൈഡഡ് ബൈ എ ഡിസ്ട്രിക്ട് ജഡ്ജ് എന്ന് അതിനകത്ത് പറയാൻ കാരണം. സോ ദാറ്റ് ഈസ് ദ റീസൺ that becomes a special statute with respect to all that particular intellectual property, and this is a general procedure. ആ റൂൾ എടുത്തു വരുമ്പോൾ അങ്ങനെയാണ്. അത് കണ്ടുകൊണ്ടായിരിക്കാം അവര് 11 സ്പെസിഫിക് ആയിട്ട് ഈ കോൺഫ്ലിക്ട് റിസോൾവ് ചെയ്യാൻ വേണ്ടി ക്ലാരിഫൈ ചെയ്തത്. 11 പറഞ്ഞ എന്താണ്? 11 പറഞ്ഞു അതർവൈസ് ബാർ. അപ്പൊ എവിടെയെങ്കിലും ഒരു ബാർ നിങ്ങൾ ട്രേസ് ചെയ്ത് കഴിഞ്ഞാൽ then the commercial court need not insist this as a commercial dispute that he himself will alone decide എന്ന് പറയാൻ പാടില്ല. അതാണ് 11 ക്ലാരിഫൈ. ഒന്നും കൂടി വായിക്കാം, പലരുടെയും ബുക്കില്ലാത്തതുകൊണ്ട്. Notwithstanding anything contained in this act, total ഇതിനകത്ത് എന്തൊക്കെ പറഞ്ഞിട്ടുണ്ടെങ്കിലും commercial court or a commercial division shall not entertain or decide any suit, application or proceedings relating to any commercial dispute. അപ്പൊ ഈവൻ 17 വരുന്നതാണെങ്കിൽ പോലും 17 എന്ന് പറഞ്ഞാൽ 2C17 intellectual property. Any commercial in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any law for the time being. Now, avade district court and specific designate idu koduthittullana, not any civil court, not a jurisdictional civil court. But trademark il 5,000 രൂപയുടെ dispute ആണെങ്കിൽ മുനിസിപ്പൽ കോടതി അല്ല, it's a designated body. 11 ലക്ഷത്തിന്റെ ആണെങ്കിലും സബ്ജക്റ്റ് അല്ല, it is again a district judge. ഒരിക്കലും ഡിസ്ട്രിക്ട് ജഡ്ജിന് അല്ലെങ്കിൽ കിട്ടാത്ത ജൂറിസ്ഡിക്ഷൻ ആണ് ഈ സ്റ്റാറ്റ്യൂട്ട് വഴി കൺഫർ ചെയ്ത് കൊടുത്തിരിക്കുന്നത്. സോ ഒറിജിനൽ സെക്ഷൻ 9 പറയുന്ന ജൂറിസ്ഡിക്ഷനിൽ തന്നെ സിവിൽ കോർട്ടിൽ നിന്നത് പുറത്തേക്ക് പോവാണ്, ഇംപ്ലൈഡ്ലി ഓർ എക്സ്പ്രസ്ലി. എക്സ്പ്രസ്ലി ആണെങ്കിൽ അണ്ടർ ദ കോഡ്, ഇംപ്ലൈഡ്ലി ആണെങ്കിൽ വേറെ ഏതെങ്കിലും സ്റ്റാറ്റ്യൂട്ടിൽ റെഫർ ചെയ്തിട്ട് ഇതിനകത്തൊരു ബാർ വന്നാലും മതി. സോ ദിസ് ഈസ് ഹൗ വി വിൽ ഹാവ് ടു ലുക്ക് ഇൻടു. Yes.
Okay, sir. One more question. Section 9 deleted ആയിട്ട് സെക്ഷൻ 9 ഡിലീറ്റഡ് ആയിട്ട് കാണിക്കുന്നു. അത് അതിനെ കുറിച്ചൊരു ക്ലാരിഫിക്കേഷൻ
ഏതാണ്?
സെക്ഷൻ 9 ഓമിറ്റഡ് എന്ന് പറഞ്ഞു സാറ് തന്ന പ്രസന്റേഷനകത്ത് അങ്ങനെ കാണിച്ചിരുന്നു. അതുകൊണ്ടാ.
അയ്യോ ഇല്ലല്ലോ, ഐ ആം സോറി. ഒന്ന് നോക്കി നോക്കൂ. പ്രസന്റേഷൻ ഇത് മാത്രമേ തന്നിട്ടുള്ളൂ, സ്റ്റാറ്റ്യൂട്ടും ഇത് മാത്രമേ തന്നിട്ടുള്ളൂ.
അതിനകത്ത് സെക്ഷൻ 9-നകത്ത് ഒരു ഇത് വന്നിട്ടുണ്ടായിരുന്നു, നോക്കാം.
സെക്ഷൻ ഇതിൽ ആദ്യത്തെ സെക്ഷൻ അമെൻഡ് ചെയ്തിരിക്കുന്ന 26 ആണ്. അമെൻമെന്റ് 16 നോക്കിയിട്ട് ഷെഡ്യൂൾ എടുത്തു കഴിഞ്ഞാൽ അറിയാം. ഇവിടെയല്ല, ഷെഡ്യൂളിലേക്ക് പോകണം. ഇതില് സെക്ഷൻ 9 ആണോ നോക്കിയത്? ഈ സെക്ഷൻ, ഈ ആക്ടിലെ സെക്ഷൻ 9
അല്ല, ഇതിനല്ല, സോറി.
ആണോ? ഇല്ല, അല്ല, എന്റെ സ്റ്റാറ്റ്യൂട്ട് വേറെ ആക്ടിന്റെ ഇരിപ്പുണ്ട്. ഇതിൽ ആദ്യമായിട്ട് അമെൻമെന്റ് വരുന്നത് ഇതാണ്. യെസ്,
can we obtain interlocutory order from a commercial court?
Sir, it is this way.
Can you hear me?
Yeah, sure. Interlocutory orders with respect to commercial matters can only be obtained from, be it a final order or interlocutory order with respect to commercial dispute can only heard from, obtained from commercial court. But Yana interlocutory paranjada order 12A pre-litigation, pre-institution mediation avoid cheyanannundengil adodu koodi koduthu kazhinjittu kekkanennu paranjal nere pogam. Adana njan ayinathu interlocutory.